The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. Welcome you to the January 10th, 2024 settings of the 7th Court of Appeals. I'm still wondering where last year went. And if you blink, this year's going to be gone too. Somebody told me once that it's true. The older you get, the faster time goes by. And in my case, it seems to be very true. But we do thank you for coming up here to Amarillo during the good weather and agreeing to submit your argument here. We have two cases this morning. I'll go on and call the docket for the first case. After that, we will take a brief recess so we can switch panels, and then we will begin the second case. The first case we have for this morning is 07-23-00031-CV, Jane Nelson in her official capacity as Texas Secretary of State versus True Texas Project, Texans Uniting for Reform and Freedom, Grassroots America, We the People, Julie McCarty, Terry Hall, and Joan Fleming. And I understand that the Attorney General is here, and I'm assuming you are ready?
Yes, Your Honor.
Great. And representing the appellees?
Tony McDonald and Connor Ellington.
Very good. And I'm assuming you're ready here. Very good. Mentioned earlier that each side has 20 minutes to present their argument. Of course, the appellants have a 5-minute rebuttal automatically. You do not have to reserve your rebuttal. With that, and I want to say good morning to the deputy too. She's kind of hard to see her from my angle. I'm kind of short and can't quite see her, but thank you for coming and taking care of us. And with that, Ms. Klussman, you got the floor. If you have water, feel free to take it up. There is water up there, so.
Good morning, and may it please the court.
Counsel.
In 2021, a significant majority of Texas voters approved Proposition 2 to amend the Texas Constitution and allow counties to engage in tax increment financing. Contestants have asked the courts to void that election, arguing that the legislatively chosen ballot language was objectively misleading. The 3 jurisdictional obstacles prevent the court from granting the relief contestants seek: sovereign immunity, the political question doctrine, and separation of powers.
Not just that it relates to this case, but I understand that there has recently been filed another lawsuit contesting the verbiage on the latest round of constitutional amendments. Do you know anything about that?
I've only read some news stories about recent ones. I think it was claims of fraud in various elections, and that the governor decided that it had been filed too late, and so has just moved forward with those amendments. But that's only what I've learned from news stories. So I'm unaware that it has any relation to this case at all.
Second question.
Yes.
If I'm not mistaken, you represent in your brief that your arguments presenting or issues of first impression.
Yes.
You have not encountered, and I would ask the opposing side to answer this too if they have encountered, but you have not encountered any case where the issue about separation of powers with regard to constructing or construing the sufficiency of the ballot language has been addressed.
I have not, Your Honor. The closest I have seen is an amicus brief filed in the Dacus case in the Texas Supreme Court by the Texas Municipal League, where they argued that the sufficiency of ballot language shouldn't be judged under the common law, but by city charter standards. And so they didn't make a specific separation of powers argument, but that's the closest I've seen to an argument that the common law shouldn't apply. And the court rejected that, saying, no, this is just what we do in these cases. And so that's the closest I've seen. I have not reviewed briefs from really old cases are online, but presumably if it's a jurisdictional issue, courts would have been required to address it.
And we're not concerned in this appeal whether the common law is the correct application of law or not. We're only dealing with whether we can hear the case, isn't that right?
Yes, if the common law standards applies, then at this juncture, we're not challenging the way that the Supreme Court's articulated that.
Well, that is kind of related to your second issue. If we were to get past separation of powers political question, then your second issue addresses whether or not they've presented sufficient evidence to raise an issue about the sufficiency of the ballot language under the common law, correct?
Correct, Your Honor. Using the standard the Supreme Court has articulated. And because all of our issues are jurisdictional, the court can address them in any order. And I do think that that sovereign immunity question, whether or not they have pleaded a viable election contest, is the most straightforward way to resolve the case. It doesn't require the court to reach any issues of first impression or break new legal ground. But we do have Texas Supreme Court precedent sort of explaining how this standard applies.
And you're talking separation of powers and political question. The way I read your brief, they are separate, or are they one and the same? Or is one the political question a subset of separation of powers?
They are related, and I think that's what the Texas Supreme Court has said, is that political question is a function of separation of powers. So I see separation of powers as sort of a broader issue, and then political question is sort of a more focused analysis. I mean, that's how I see it. They are separate, but they are certainly related. So I was going to go ahead and start with the sovereign immunity question about the character, purpose, and chief feature of the amendment. Just as I said, we've got a little more Supreme Court precedent on that point. And the requirement is that you cannot affirmatively misrepresent the amendment or omit its character, purpose, or chief feature. And what we know from Supreme Court precedent with respect to omission, which is what this case is mostly about, they've only identified so far one category of information that cannot be omitted without making the ballot misleading. And that's that question of costs. If voting yes is going to impose significant costs, then you need to put that on the ballot. So that we get from Dacus, where voting yes in Dacus was not just creating a fund, but actually agreeing then to have a charge imposed on property owners in order to put money into that fund. You also see that in In re Petrocek, which was to enhance police standards, put more police officers on the street, and that was going to cost the city between, I want to say, $280 and $500 million over a period of 5 years. And so the court said that kind of direct financial impact needs to be on the ballot. That's not what we have here. Here, unless you own property in a blighted or undeveloped area and your county decides to engage in tax increment financing, you're not going to see any costs as a result of voting yes. This is sort of a contingent chain of events where the county first has to decide to engage in tax increment financing, and then your property values rise and you pay more property taxes as a result. But that again is just common sense if your
Why
property
should
values
the
go up.
Supreme Court be allowed to tell legislature that they should include that language on the ballot language?
I missed the first part.
Why should the Supreme Court or any court be able to tell the legislature that they should include that language?
Well, we don't believe that the court should be allowed to do that. And so, I mean, I'll go ahead
Is
and.
there any disagreement among the parties that in the first instance, the legislature, under the Constitution, the legislature has the opportunity or is given the right to draft the ballot language?
I don't understand contestants to be arguing that the legislature can't draft ballot language in the first place.
I do know that correct me if I'm wrong, if they don't, then the Secretary of State can draft that language into the statutes or something like that.
Yes, by statute, if the legislature does not, then the Secretary of State does. That was not obviously the process used here. I've actually never seen it. Most of the, or actually all of the constitutional amendments I've seen, the legislature has included the ballot language itself.
Okay, and that is by statute though, it's not by Constitution, correct?
The Secretary of State piece, yes, that is by statute.
Okay.
So we'll just continue down that road with political question. The Supreme Court has given us sort of 6 potential circumstances in which that's implicated. We know that the Texas Supreme Court has certainly looked at the first 2 instances, which are a textually demonstrable commitment of the issue to another branch. and then a lack of a judicially discoverable and manageable standard. Those are kind of related. And that's the situation here. First, obviously Article 17 of the Texas Constitution commits proposing constitutional amendments to the people, to the legislative branch. And there's no role for the courts in Article 17 other than posting the amendment in the courthouse somewhere. And so there's no opportunity for the court to review ballot language under Article 17. And if it were to do so, the Constitution does not contain a judicially discoverable or manageable standard for doing that. Again, it's silent as to what the ballot language must look like. And if we look at sort of general principles of law, we have the general rule that the legislature can act whatever law it wants as long as it's not unconstitutional, and that courts do not question the wisdom of legislative policy decisions. And I think
75 years ago in the Sterling Oil case, the Supreme Court certainly exercised jurisdiction in. It looked at ballot language for a proposition for a constitutional amendment. It applied a standard. Was the Supreme Court wrong in doing so?
I will say that I don't believe this issue was raised, so
Does it have to be raised?
if it's jurisdictional, theoretically it shouldn't, but again, courts and parties, only see the issues that, they see. If no one noticed this issue back then no one would have raised it, and it would
To
not
what
have been
extent
passed.
can we imply that because in Sterling Oil and other cases since then, that the court addressed the issue, applied common law, that they implicitly rejected your argument?
I guess
You start out with the proposition, the court's supposed to determine its jurisdiction sua sponte.
it is, Your Honor, but we also know that we don't always notice all of the jurisdictional issues in a case. And so, like I said, I'm unaware that issue was raised in Sterling Oil, and because the court ultimately found that the constitutional amendment was fine, that, I think, if it had struck it down, I think maybe, you would have thought maybe it had to dig a little deeper and figure out if it was allowed to do that.
And I guess I'm viewing it from a slightly different perspective. If this case were being presented right now in front of the Texas Supreme Court, as a question of first impression, and said, no, we don't have jurisdiction, then the court would have to go back and implicitly overturn Sterling Oil, would it not? By saying that it was jurisdictionally infirm, or something like that, right?
I guess the answer that in Sterling Oil would have been, well, and in Sterling Oil, that wasn't, strictly speaking, an election contest. I believe that was people who brought suit after the fact were, the direct appeal had been used against them. And so this was, the jurisdiction over the suit didn't rise and fall on the election contest procedures. It was just an argument made in there. So I guess what the court would have said is, instead of addressing the merits of the argument, they should have said, we don't have jurisdiction to consider that argument. And so I don't know that you would have overruled the decision, but you would have said maybe we shouldn't have reached that piece.
Well, maybe the Supreme Court can sidestep that. I think the problem the Seventh Court of Appeals would have is telling the Supreme Court, oh, by the way, in 1949, you didn't have jurisdiction and you shouldn't have answered that question. That creates additional questions about vertical stare decisis on whether we have to defer to what the Supreme Court did or not.
Absolutely, Your Honor, and that's why we sort of began my argument today with the sovereign immunity issue. If the court does not want to have to wrestle with, do we tell the Supreme Court that you think they got it wrong back in the day, you can rule on these sovereign
How
immunity
many
grounds.
opportunities does the lower court get to tell the Supreme Court they were wrong?
I don't know if I want to answer that. So, let's see. I'll just go back to sovereign immunity just for a little bit and wrap up that argument. As I said, sort of these direct costs are one thing that can't be omitted, but in every other context, when we're talking about the details of a statute or a proposed ordinance, the court has said you don't have to put all those details in there. So in Sterling Oil, they said you don't have to put all those details in there. I would also point the court to the recent decision in Ray Petrocheck, in which the ballot language effectively, the proposed ballot language was effectively an ordinance to enhance public safety by establishing minimum police standards. It was a little longer than that, but it was about that vague. And the court said that was fine, other than adding in the piece about the cost. They said just talking about enhancing public safety and establishing minimum police standards, you didn't have to list all those details about how you were going to enhance public safety, what standards you were going to set. And so when you set that next to what we have here about financing improvements in blighted and undeveloped areas, again, we don't have that direct cost piece, and so that's not a fatal omission, but we don't have to include all the details of tax increment financing. I think if you look at sort of this is sort of the fourth constitutional amendment proposed regarding tax increment financing since 1977. The first two didn't say anything more specific other than, I think they used the word bonds. It said, to use bonds to finance improvements in blighted and undeveloped areas. I think the third one, the 2011 amendment, is the only one that gave any information about tax increment financing and how you're going to pay those bonds back. So again, I think those are the kind of details that the Supreme Court would not require to be part of the amendment or the ballot language in order for it to not be misleading. And again, we're judging this under a very loose standard because it's sort of a legislative policy decision. Was it arbitrary for the legislature to decide that this language conveyed the purpose and features of the amendment? And under the Supreme Court standards that we know right now, it did not. Going back then to political question a little bit, we talked about the lack of the judicially discoverable and manageable standard. The other side has, well, and obviously has been pointed out that we do have this misleading standard, and our argument, of course, is that doesn't come from the Constitution, and it does make a difference in which context you use it. So if we look at the American Canine case, that was the instance of the dog kennel in Afghanistan, in sort of a combat zone. If you had taken that situation and put it in Texas with civilians, that's an easy negligence case. But because it was going to require the court in that context to second-guess military judgments, what would be a normal case suddenly becomes one that is barred by the political question.
Recently, though, the Supreme Court's come back in another case involving the military and said this does not present a political question because this does not involve military decision-making and things like that. Is
Correct.
that right?
Correct. That was the Van Dorn Preston case. And so
yeah. What's the difference between these two and why you think this presents a political question versus not?
Mm-hmm. So in Van Dorn Preston, the issue was a private contractor, whether they had adequately performed maintenance on a helicopter. And they had a checklist given to them by the military that they needed to do. And so you weren't second-guessing military judgment, it's did you follow the list? And so we didn't have to ask whether the military did any, what the military's discretion was there. Whereas in American Canine, it was how do we build these kennels, what's the best way to do this in a combat zone in Afghanistan? And so that implicated military judgment in a way Van Dorn Preston didn't. And so when we look at here, what we have is, yes, courts can determine whether something is misleading. We have fraud cases, things of that nature. But when you put it in the context of the legislature has decided what the language should be for a constitutional amendment, that's a different context than private parties, arguing about a contract or a misleading advertisement or something of that nature. Now we're questioning the policy judgment of the legislature.
Well, but isn't there always an extent of where we're going to be doing that? Let's say, take for example, the legislature decides to amend the family code and says, okay, we're going to provide certain provisions in the family code, but they only give you 1 day to respond to a petition. And the legislature puts that in the family code. And there's an argument to say, well, that violates notice and due process, procedural due process grounds. I don't think the state can come back and say, well, political question, because that depends on the discretion of the legislature in deciding how much time is appropriate. I think there's an independent standard the court can say, we can exercise jurisdiction to determine whether it comports with the constitutional requirements or not.
I would absolutely agree, Your Honor, but in that case, the standard, the judicially discoverable standard, is the due course clause in the Constitution.
So it's a constitution as opposed to that it's being tested against a constitutional provision, another constitutional provision as opposed to some concept in common law.
Correct. That's the distinction that I would draw, whether you're applying the Constitution to limit what the legislature did, or whether the court is applying its own court-made common law to what the legislature has done. And I have not seen another circumstance in which the court has said that legislative act is unlawful because of the standard we have created, as opposed to one imposed by the Constitution.
Well, the standard used here, if we were to address your second issue, that standard has changed over time too, hasn't it? There was, in Sterling, they talked about, these are the things we look at, but down the road, and I think that was picked up by the Austin Court of Appeals in the Whiteside case, they applied that standard, but then within the last several decades, or last decade, this century, so to speak, they changed it. They say, we're not gonna use that anymore, we're gonna use this, didn't they?
If you're talking about the Dacus case, I think the standard was unclear. We had just what was said in Reynolds, which wasn't quite ballot language, was about calling an election, and then we had what was said in Sterling City about whether there was sufficient detail. But as far as the Texas Supreme Court goes, that was really all the explanation we had. And so I think what you saw in Dacus was the court recognizing that the Court of Appeals is sort of split on that issue. What is the standard that you're supposed to apply to ballot language? And so Dacus sort of brought all of that together and articulated sort of more thoroughly what that standard is. So I don't know that I would say it changed, it was just
It was not clear.
It was not clear, certainly.
And doesn't that satisfy one of the political question factors? It's not clear.
It is, Your Honor. Again,
And it may be clear now until the Supreme Court decides to change it again.
true. And so again, because the court wasn't looking, it was looking to its own prior precedent and to what other courts of appeals had said to create the standard, rather than looking to the text of the Constitution to figure out what limits are there on ballot language.
Let me ask you a public policy question. Where does this leave voters? Voters go to the ballot box, they vote on something, there's an argument on whether they believed or didn't believe that what they were voting on actually is what they got. But let's put it in a different situation. They vote on something, clearly the language in the enabling language of the bill or the constitutional statute or provision says something completely different. Are voters just out of luck? What do you do under those circumstances?
Yes, and that gets us to sort of what the political question doctrine is. Is it something that the courts fix or something that's for the political process? And I would say that's for the political process. If the legislatures lies to the people essentially, then the people vote in new legislators.
Has it actually lied? Because the only thing the voters, the ballot language is not the only thing the voters are being given the opportunity to see.
Correct.
They're also being given an opportunity to read an explanatory statement drafted by the Secretary of State, if I'm not mistaken, and approved by the Attorney General.
Correct.
And they're also given the opportunity to see the amendment itself.
Correct.
Don't those all have to be public?
They do, Your Honor.
So because a voter may be too lazy to investigate, they can say, King's X, we can set this aside because I could have found out. All this language is there. They provided me the opportunity. But I didn't want to look at it, and I sure can't tell what's going on by that ballot, so let's set aside the election. Is that the outcome?
I had sort of two different hypotheticals. So I understood yours to be suppose they just do something that's completely different. And yours is a little more, you had the opportunity to look it up. And so the court in Dacus said, yes, we do presume that voters educate themselves about amendments, but the court wasn't going to rely solely on that when it came to ballot language.
Isn't that sad?
But what?
Isn't that sad that we are not willing to presume that people will read and investigate things that will affect their lives?
I would like to presume that voters know what they're doing when they vote yes or no. But the Supreme Court has given us the standard, and so we're working with what they've given us, and so that's.
Did she answer your question? I'm sorry.
I think so. Your answer, and I don't want to cut you off short, but your answer is that's part of the political process, vote in different legislators or different politicians next time you've got an election. Is that what I understand you?
Yes, Your Honor. I mean, I would compare it sort of on a smaller scale to a legislator who promises one thing if you vote him in and does something else. Like that's something you just fix through the political process.
Thank you.
Thank you.
You have 5 minutes to rebuttal. Counsel?
May it please the court. The Supreme Court explained in Dacus v. Parker that the common
Let
law.
me ask you the first question. I asked opposing counsel, have you encountered any case that expressly addressed the issues here with regard to separation of powers and political question vis-a-vis the wording of a constitutional amendment on the ballot.
No, Your Honor, I think the arguments brought by the Secretary in this case are completely unprecedented. As I was saying, the Supreme Court in Davis v. Parker explained that the common law protects the integrity of elections. It protects voters in little things like a drainage fee. But the Secretary's argument is that that common law would not protect voters in the biggest thing, amending our fundamental charter, our state constitution. Thankfully, that was rejected, not just in Sterling, but 75 years ago in Whiteside v. Brown. Binding precedent on this court in this administrative transfer, the Austin Court of Appeals in Whiteside v. Brown looked at the question of whether ballot language was sufficient. They found it was, but they looked at that question. They rejected the concept that there was no common law standard, what they called the general rule.
In fact, they looked at the question. Are we to read into it implicitly that the Supreme Court rejected the appellant Jay Nelson's argument with regard to separation of powers and political question?
I believe that these arguments are precluded by the Whiteside decision. And to be clear, we don't know about the party presentment principle. I haven't looked at the briefs there, what was presented, so I understand that. And it is a very passing glance at the question. It's the final issue in the case, and they go through it quite quickly. But there is some analysis there where they say they actually looked at the statute, the predecessor statute, that sets a standard for now the Secretary of State when there is no ballot language. At that time, it set up a standard for the governor. And they said, well, by parallel, we think that the same standard applies as what is here in the statute for the Secretary of State. That applies to the legislature. And then they also say, and the general rule. So what would the general rule be? It would be the general common law rule.
Are they talking about the standard in determining sufficiency, or are they talking about jurisdiction?
I believe they're talking about the standard, the sufficiency, and what was refined and what has actually been drawn out. In
Back to
that
my question, though, do you think from these prior cases, both Supreme Court, Whiteside, et cetera, to the extent that they looked at the sufficiency,
Correct.
are we supposed to infer that they also looked at jurisdiction and said they had jurisdiction?
It's implicit, but obviously not express. And so obviously if we had a case where there was an express ruling on jurisdiction, that would be stronger. But
One of my concerns about Whiteside is that if you look at the writ history, it was dismissed without jurisdiction when petition was brought in the Supreme Court. So obviously we don't know if what happened there was a petition for review filed too late, or are they saying we don't have jurisdiction because it's a political question?
I noticed that too, but I don't have the answer to that, unfortunately. We would ask, beyond this, just this presidential question, we would ask this court to respect the will of the legislature in setting out the contours of an election contest. The legislature said in section 233.014G that you can bring an election contest on a constitutional amendment election. It says any question related to the validity or outcome of a constitutional amendment election may be raised in an election contest. And that is the exclusive method for adjudicating such questions. Well, if you think about that, that's actually a very narrow role for the judiciary that the legislature has picked out. You know, there have been other interventions into ballot language at the local level. I know just a couple of years ago there was a challenge to the city of Austin's camping ban that went to the Texas Supreme Court. And the court stepped in before the election and rewrote the language there. They actually took a couple of words out. It was a very kind of surgical strike kind of thing. The legislature has said to the courts, we don't want you doing that. You're not allowed to do that in these constitutional amendment elections. Your role is to look after the election at the validity of that election. And so that actually is, in terms of separation of powers.
Validity of the election, does that go down to the issues akin in our election fraud, if you will, versus how clear the ballot language is?
Well, it would encompass, again, what the legislature said is any question related to the validity. So, of course, it would encompass if there was election fraud or if
If-
counting was done.
If somebody objected to the date that the election was held, the Constitution gives the legislature the authority to select that date. Can the Supreme Court say, you're right, we don't like that date, legislature, you were wrong, we're gonna set aside the election?
Well, the courts are bound by the rule of law. Obviously, these decisions should not be arbitrary, but,
This age is not fair, they chose a date that, 4th of July, so to speak, everybody's out partying, setting off firecrackers, so that minimizes the turnout at the election. You know, we think it should require more opportunity to vote. Can they do that, or is that a separation of powers? It's clear the legislature has the authority to select the date.
the difference there is that there's no common law precedent establishing, well, we don't do elections on
Common law is
Christmas.
just what the courts say, so couldn't they come up? Common law changes, common law develops.
Common law develops, but that's something that was brought up in one of the briefs where they described the common law rule as, writing a rule out of whole cloth, and I thought that was a bit, almost insulting to the concept of common law. Common law is the discovery of law through a long line of case law. Here we do have a judicially discovered standard, is very clearly pronounced in Dacus v. Parker, where we have a standard that says you don't actively mislead and you have to touch on the chief features. This is interesting, talking earlier about the concept of kind of the disappointment that we might have, that folks wouldn't go and just read all the documents and that sort of thing. There was a whole line of cases that I think were completely respectable that held just that. They said, well, we presume that people know what they're voting
Because
on,
we're rejected.
and they have to pick it. But the Supreme Court rejected that. The Supreme Court said, we're going to actually require more. The common law requires more. It requires this minimal threshold to say, don't actively mislead, and we're going to require that you identify the chief features.
What other instances do the courts use the common law to test a constitutional act?
Well, this goes back to the whole question. This is a Marbury v. Madison judicial review question. In a sense, courts do it frequently. It is a high standard, but
They use the common law to say that constitutional act is wrong. In fact, the
Well-
common law can't subjugate the Constitution, correct?
correct. Actually, I have a better answer for you, and I'll direct you to Cash America International v. Bennett. That's the Texas Supreme Court coming in and saying, when there is a common law right, you have to have an express textual abrogation of that common law right. And so what that stands for is a precedent. Of course, if the legislature comes in and expressly abolishes some common law cause of action or redirects that sort of thing, the legislature can't do that. But it requires it to be very express and out there, not implied. And I think what's the difference here is that you have a common law standard that protects voters. There's been no precedent that suggests it doesn't extend to these constitutional amendment elections. We have the legislature saying that you can bring an election contest in the constitutional amendment context. And yet there's this idea that there's an implied abrogation of that because the legislature has the initial role in setting the ballot language. I just think that is unprecedented.
I guess go back to my other question then, given that the legislature allows suits on any question, it's possible the Supreme Court could entertain a suit on the day of the election selected by the legislature. I guess that would logically flow from your argument.
I think it's logically flows that it could entertain that. I don't think that would be a winner, because there's no precedent that I'm aware of that would suggest that that's a winning suit. But I don't know that that's something that you should shut the door on. If they set the election on Christmas, is it unconstitutional under the common law to set the election on Christmas? Well, I don't think there's really a precedent to support that, but that's a novel question. That's an interesting question. I wanted to turn a little bit to talk about what this case is about, what the actual Prop 2 was about. Now, to be clear, we do not think that the court should reach the merits in this appeal. We don't think sovereign immunity applies to an election contest of this nature. There's no precedent of sovereign immunity being applied to an election contest. So if that's true, if there is no sovereign immunity in a contest of this nature, then you just never reach that validity question. But let's say the court does. And it's important to understand the context. As it
Can I ask
stands,
you a question before you get into this?
Sure.
What relief did the petition you filed ask the trial court to do?
the relief that is, the only relief allowed under the statute, which is to order the governor to declare the election void. And that's a very specific thing in the election code. That's what the legislature has laid out as the sole remedy that's available. And so that's the only relief requested.
You're not asking that the court
Pardon?
on the language.
I'm sorry, I was distracted.
Yeah. So you're not asking that the court give their opinion as to the language that the legislature should use.
Correct. So the election code makes clear that this court, trial court, cannot order a new election, cannot pick new language. It can do one thing and one thing only. It's a very limited role to say we're going to avoid this election because essentially you didn't really ask the people what they thought about this
But
proposal.
in telling them, they're gonna have to point out what was omitted from the proposal, correct?
Correct.
In pointing out what was omitted, isn't that pretty much the same as telling them you need to include this?
In a sense, but it isn't saying to the legislature, well, this is the form that it must take. You're talking about, is it below or above the minimum threshold of notice that was required to the voters, not precisely here's how.
And then the next time it happens, they say, that's still not enough. And then next time, that's still not enough. And then next time, that's still not enough. Isn't that pushing the legislature to write in a certain way eventually?
If that unlikely series of lawsuits over many decades would take place, I mean, it could, but I really don't think that's something that we're at risk of. And actually, let me speak to that. The legislature has stepped in the intervening time between when this contest was filed and now. They have stepped in to actually amend the statute to try and put shorter time frames and try to make sure that these types of contests are resolved more quickly. And it doesn't impact this case, but it will impact all future contests. What they didn't do.
Before the election or after the election?
Always after the election. You can't bring the election contest to the first day you file is the day after the election. So always after the election. But what they didn't do was carve out certain types of claims. So they could have stepped in and said, well, we don't want to have our language tested in these contests. And that would have raised interesting due process questions of abolishing that type of relief. But they haven't done that. They've left any claim related to the validity. That language remains. And they said we want these things resolved more quickly. To talk a little bit on the merits about what's going on with Proposition 2, you have to understand that as it stands today, counties cannot do tax increment financing, and that is because it's deemed to violate.
Curiously, to what extent can the legislature, assuming it is a power vested in the legislature, to what extent can the legislature say another branch can supervise its action? That's what you're suggesting. That's what I'm reading into by any question.
Well, that is what the legislature has done by creating this election contest. I think, I don't think there's any question that the legislature has the authority. There's never.
Do you question that the legislature has the authority to adopt appropriation bills in the first instance? Or to enact appropriation bills in the first instance? It's part of the Constitution, right? That budgets come out of the legislature,
Right.
okay? Can the courts go on there and do their own budget? Do their own appropriation bills?
No, the
Okay,
correct.
separation of powers.
Well, and just express granting of powers even.
Okay. Can the legislature say, okay, Constitution says the appropriations should first come from the legislature, but we're gonna allow the executive to propose those bills first, or we're gonna allow the judiciary to do that? Can they delegate that?
Well, so actually the Constitution provides for the governor to write a budget, which is interesting and unusual. But
But the bill doesn't come from the governor's office.
well, they actually, like constitutionally, they are required to submit, they actually submit in practice like a budget that just basically mirrors what the legislature does. But the Constitution calls on the governor to write a budget as a proposed budget for the legislature. So I think the submission of proposals to the legislature really
That's
doesn't
from the
interfere with its power.
Constitution.
Well, and
How about it?
let me help you with an example, maybe. It's federal, but bear with me on the federal issue. Certainly, when McCain-Feingold got tested in the United States Supreme Court on whether the president could make a line item veto, the Supreme Court shot that down as a violation of the separation of powers, saying Congress has got the sole responsibility of creating the budget for the country and not the president, right?
Right.
And I think that's what the chief is trying to address, is to say, are there times when one branch of government is trying to dictate to another branch of government that you run into a separation of powers argument?
Not just that, but can Congress enact a statute and said that the president has line item veto? When the Constitution says the legislature is the one that's supposed to do the appropriations.
Well, obviously, there are cases like that line item veto is a brilliant example of the legislature wanting to give power to another coordinate branch, and that branch saying, no, actually, you're not allowed to delegate this power to us. And that does happen. But here you would be saying, okay, we're going to override the choice of the legislature. We're going to basically declare 233.014G unconstitutional as applied to this type of challenge, because we don't think that the legislature can let the courts review its ballot language. I think that's a rather bold, there's no precedent for that.
This
in all
is
the
an
case laws
issue of
contrary
first
to it.
impression. There's no precedent for any of this, so what's the matter? That there's no precedent.
Well, it matters that the precedent, it actually weighs in the other direction as courts do look at these questions before. But briefly, before we finish, because we're running out of time, I wanted to talk about the context of what this proposal was. We're talking about amending Article 8 of the Texas Constitution, which imposes an equal and uniform taxation rule on property taxes across the state. Texans, as property taxpayers, are entitled to expect that their taxes are equal and uniform. This proposal is an exception to that. And you've had it proposed for decades where they've wanted to give this authority to counties to do this type of unequal taxation for the benefit of property developers. And the merits of that is obviously not subject here, and it's obviously debatable. But that's what we're talking about. So we're not talking about something that impacts just a limited group of people who are
What
in
should
the
have been,
zone.
in your view, what should have been included in the ballot language?
The 2011 proposal was substantively identical to what was proposed here. There, they mentioned both bonds and notes and the fulfillment of those bonds and notes through the increases in ad valorem tax revenue. When you look at Article 8 and you look at the fact that this is an exception to the equal and uniform taxation rule, I think at the minimum there had to be some signal to voters that this had to do with unequal taxation. It had to do with tax breaks, it had to do with TIF financing, or at the very least it had to do with debt.
Did do that in your view?
2011 absolutely did that in very good detail, and the voters rejected it 65-35. And so this is entirely it's a callous political calculation that went on here.
Of course, it was rejected, but the ballot language in 2011 wasn't tested by anybody.
Well, it couldn't have been tested because it was, well, I guess the proponents could have tested it, but
So nobody said that was overly informative or underly informative. It's just.
there was no contest. And again, that predated Dacus, and so very unsurprising that you would not have seen a challenge.
That doesn't prevent voters from readdressing the issue. As you're aware, there was a recent constitutional amendment that got voted down, 1 out of 14, dealing with judicial pay raises and things like that, retirement age.
Retirement.
Voters can come back. There's another ballot on the future election and decide to change their minds, right?
And indeed, if the relief requested in this contest is granted, the legislature will have its opportunity to propose sufficient language and take another crack at it.
Who determines if it's sufficient, Supreme Court?
It would be the trial court first. If the trial court wished to
The
do that,
judiciary determines if
the
it's sufficient?
judiciary, and ultimately the Texas Supreme
And
Court.
then if the judiciary doesn't like it, they tell the legislature, again, it's not sufficient, you gotta have more.
Correct, and that's the standard set out in Davis. Yes, sir. Thank you, Aaron. Ask you to affirm the trial court.
Yeah, so when was the election contest statute, the 233, was that before or after 2011?
When was that statute created?
Yeah.
I don't know, but it would predate. It's an older statute. I don't know the precise date. It's been around. It's not a new statute.
Thank you, Counsel.
Do you know, well, you may have just answered the question, do you know if it predated Sterling or Whiteside?
Well,
Would it come back to the 1940s then?
something would have had to, I don't know if it's in its precise form, and I'm happy, if you'd like, I can do like a post hearing, brief or something if you'd like. But and answer that history as best I can. But in Whiteside, they were looking at a constitutional amendment challenge. And so that was, there was some mechanism in place, whatever, if it was identical, I don't know. But there was a mechanism in place there in 48 to allow that type of contest.
Thank you. Bill?
Thank you, may I please support again?
Legislature said they can review any question in these election contests. Has the legislature said, sure, you can review the language, it's not a political question. It's not separation of powers.
No, Your Honor. First of all, the legislature couldn't give the court's authority to answer a political question because by definition that comes from the Constitution. So if it's a political question, the Constitution forbids the courts from reviewing it. By statute, you cannot overcome that.
So you can't delegate.
No.
You can't delegate, in your view, Attorney General's view, state's view, you cannot, legislature cannot delegate a power vested to it.
I would say there's levels of delegation, right? You can delegate to an agency as long as you give them sort of the parameters for which they can make rules, but like a core legislative function, like passing the law in the first place, you can't delegate things of that nature. And so if to the extent that this is a political question or barred by separation of powers, you wouldn't be able by statute to give courts the authority because that would require a constitutional amendment in order to do that.
Well, what would be the point of 233.014 then? We're gonna say you can do it, but you really can't?
Well, no, that would cover any other claims brought up in an election contest, such as, fraud at the ballot box or, things of that nature that you normally think of.
Well, if it's misrepresentation, is that not fraud at the ballot box?
I guess I would say no because fraud requires an intent to deceive and this misleading ballot language standard does not require that. So, but just what I was thinking of there is, the ballot, the votes that came in don't actually represent the votes that were cast in that sense. Someone altered the numbers or something like that. So those are the those kinds of election contests certainly could be brought. And anything else that's, of course, not prohibited by what we would argue separation of powers or political question. And just to sort of close that loop, we do believe that, contrary to the contestant's argument, that is an issue of sovereign immunity. Obviously, you're suing the Secretary of State, so you have to have a waiver of immunity to bring the Secretary of State to court. And here, that requires a viable election contest. We would compare it to the language found in the Uniform Declaratory Judgment Act, which permits a statute, if a statute is alleged to be unconstitutional, you still have to bring something that is not facially invalid there in order to waive immunity. And so I would just apply that same rule to the language you see here.
Do you lose on that issue if we say, it's not facially invalid, there's at least an arguable point? It doesn't seem like there's a prohibition to declaring the rights then, or at least having the trial court do that at that point.
That would, I think, if you disagree with us on that, that might eliminate the sovereign immunity argument, but then we would still have our political question and other arguments.
So what act did the Secretary of State commit? The Secretary of State did not create the ballot language in this instance.
Correct. It's,
But there's a statute, and that's the appropriate executive.
yes, Your Honor. Yeah, when you dig into this, it's very odd. If you go all the way back to 1938 in DeShazo v. Webb, there the court explained that these kinds of election challenges, not office, like two people fighting over an office, but fighting over a proposition, are essentially legislative functions that the Constitution was amended to give courts jurisdiction over these kinds of contests. And so it is odd. Under modern notions of standing, you normally wouldn't be able to have these plaintiffs or these contestants in this contestee, but this is what the legislature has set up, and so that's what we're using right now. But it is odd that the Secretary has no control over the ballot language, and the ultimate result is to order the governor to declare the election void. And so this is an odd procedure just overall. But I think just sort of then to wrap that point up with the political question, a couple of other circumstances that Baker v. Carr has recognized are whether or not it's impossible to decide without expressing a lack of respect due to another branch or the potential of multiple conflicting pronouncements from various branches of government. I mean, I think that's kind of what Your Honor was pointing to. Are we going to have election after election until we get to the point where the legislature and the courts have agreed what the appropriate language is? And that's not helpful for.
Do you agree or disagree with the proposition? I'm misstating it, please forgive me. But that to the extent that the court is not expressly saying you have to use these words, that it's really not interfering with the legislative function in adopting the words. Or it is saying that's not enough, and that's not enough, that's not enough. In effect, telling the legislature what to write.
I think, yeah, I think there's a line. The legislature still can adopt whatever it wants, but if it wants it to be effective, it's going to have to do what the court asks. And so that does give the courts control over what the legislature does. It doesn't, the court's letting them writing it for them and forcing them to vote a certain way, but by saying, we can tell you whether or not this is good enough, then the court is exercising that control, I would say, in violation of separation of powers. So for all of those reasons, we would ask the court, obviously, reverse and render judgment dismissing the contest.
Is rendition the proper remedy? If you're saying we're doing it without jurisdiction, can we render anything?
Well, you can render judgment dismissing the case. I think. That's just what I always say, to be perfectly honest, Your Honor, but I think you can, I don't know if you would tell in federal court, obviously, you tell the lower court, do whatever is in line with our opinion. I think here, the court can render judgment dismissing the case.
Dismiss for lack of jurisdiction.
Yes.
If that were the way we were going to go.
Correct, Your Honor.
Thank you.
Thank you.
The case is submitted, and you are free to leave. Again, thank you for journeying up to Amarillo. Hopefully you found your stay welcoming.
It was only cold, not breathtakingly cold. Correct.
It's refreshing, this temperature today. Sometimes it's not so refreshing. But we'll be in a short recess and have a panel swap. Thank you.